for you. One story that questions who controls a woman's body, the other about who controls your identity. We're talking about from the courtrooms to cybercrime. We're going to be decoding two battles where technology law and human rights essentially collide. But before that, the top headlines we're tracking for you. Today's Chanakya predicts the Bharatiya Janata Party to wrest West Bengal from Mamata Banerjee's control after 15 years, projects 192 plus seats for the BJP, only 100 plus for the Trinamool Congress. Meanwhile, Mamata Banerjee's show of confidence ahead of the verdict rejects the exit polls on West Bengal, says the Trinamool Congress will cross 230 seats, accusing the BJP of dictating these surveys to control the markets. The other important exit poll number from today's Chanakya predicts the DMK will return with 125 seats. Meanwhile, Vijay's TVK is set to emerge as the main opposition with 63 seats as per today's Chanakya. King or Kingmaker, 4th of May, the dust will finally settle. But actor turned politician Vijay seems to be real vigilant. Vijay chairs a key TVK huddle ahead of the verdict day, prepares the candidates for the counting, issues be at counting centers by 6 a.m. directive. The Delhi High Court grants interim relief to Karishma Kapoor, restrains Priya Kapoor from alienating Sanjay Kapoor's assets. A big relief for Sanjay and Karishma Kapoor's kids in this will row. The Supreme Court reserved its order on a plea filed by Congress leader Pawan Khera seeking anticipatory bail in a case linked to his allegations against Assam Chief Minister Himanta Biswa Sarma's wife and her passports. US President Donald Trump says he would continue to keep the naval blockade until Iran agrees to addressing concerns about the nuclear program. That's our first story. A 15-year-old rape survivor, a 31-week pregnancy, and a courtroom that's grappling with law versus lived trauma. Law versus reality, medicine versus autonomy, and the state versus individual. Who decides? Is it going to be the state, the doctor, or the survivor? We're going to be addressing a story that sits at the intersection of all these aspects of law, medicine, and human suffering. It is a case that has forced the highest court in our land to ask a fundamental question. Can justice for a victim of sexual violence ever be subject to a deadline? A 15-year-old rape survivor who is now almost 30 weeks pregnant approached the court seeking permission to terminate her pregnancy. The Supreme Court allowed the termination, saying no woman can be forced to carry an unwanted pregnancy. Now, the court made some strong observations. It said unwanted pregnancies cannot be forced on any woman, especially a minor rape victim. The judges pointed out that due to fear and social stigma, many young survivors realize they are pregnant only when it's already too late. The government and the AIIMS had argued that a 30 weeks fetus is viable and termination could carry some major risks. They suggested the pregnancy should be allowed to continue and the child could be given up for adoption later. But the Supreme Court was firm. It said the survivor's right to dignity, to autonomy and mental health under Article 21 of the Constitution must be protected. Forcing a 15-year-old child to become a mother against her will, the court felt would only multiply her trauma in the days to come. And the Chief Justice even asked the government to amend the law, fix your law, and remove the time limitation for the minor rape victims. The court said justice for these young girls cannot be time-barred. Now, the legal battle for this 15-year-old girl began in the Delhi High Court, which originally dismissed her plea by strictly following the 24-week limit. However, the Supreme Court intervened, recognizing that the trauma of rape does not end with the act and the limitation of the act itself. It multiplies. Every day the survivor is forced to carry the consequence of that crime. And this is not just about one case. It's about thousands of minor girls who become victims of rape and then find themselves trapped in a system that may not truly understand the depth of their pain and fear. The court has now clearly said that the law needs to change so that minor rape victims are not denied relief just because time has run out. The big questions that we're trying to understand on the show tonight. If our laws allow late-term abortions for fetal abnormalities, why are they denied to survivors of sexual assault who face lifelong psychological trauma? Should a medical time limit carry more weight than a minor's right to dignity and a future free from forced motherhood? And how do we bridge the gap between medical concerns regarding fetal viability and the legal rights of a pregnant survivor? Advocate Rekha Agarwal, Supreme Court and social activist, with us on the broadcast. Brinda Adige, social activist and Director, Global Concerns India, with us on the broadcast. Advocate Agarwal, let's get the snowball rolling here. Is viability of fetus more important than trauma? We've been asking some of those big questions. Should there be no time limit in these rape cases? Can courts override medical advice? Does this judgment expand Article 21 beyond the existing law? What's your assessment and reading? People are saying this is a watershed moment, what the CJI said today.
Absolutely. And as a woman, I really welcome this judgment which has been passed by the Honorable Supreme Court. And as I've always been saying in your shows, that the most important protection that every human being has in our country against any kind of a violation, is the fundamental rights. And Article 21, which guarantees us the right to live the life the way we want, is the most important fundamental right. And the right to body autonomy is included in that right, Article 21. So at no cost can any woman, and particularly a minor woman, and again, to beat it all, somebody who's a rape survivor. So such kind of a child, she's a girl child, at no cost can she be denied the right to terminate her pregnancy, which is absolutely an unwanted pregnancy, which has been forced upon her without her consent. She's a rape survivor. She's going to undergo extreme psychological trauma. So all those things are of primary importance because they're covered in the Article 21. And though MTP Act says that, beyond 24 weeks.
Exactly. I was just going to come to that. Advocate Agarwal, what's your opinion? If the courts override the 24-week limit, does the law lose relevance for all those that are talking about the legality of the law? And should rape cases involving minors have no time limit legally? What's your opinion on that front?
You're asking me or Brinda?
You, ma'am.
Yeah. Certainly. I think where rape victims are concerned, or rape survivors as we like to call them now, I think that, the very fact that pregnancy has been forced upon the child, that to a minor child, and whether it's a woman who's an adult woman, and if it is a minor child, as in this particular case, at no cost, as I just said, that the law should compel her, the MTP Act should not compel her that, look, you have crossed the 24 weeks, limit. And therefore now you must bear the child at all costs. And if you don't want the child, please give it away in abortion. You've got options available to you. So such kind of an argument or such kind of an option which is given to a rape survivor, I think is absolutely preposterous. And in the cases of rape victims, and more so if they're minors, then this time limit period which has been set, particularly, of course, keeping in mind the fact that the life of the child, of the life of the person who wants to undergo the MTP, that should not be put at risk. If there is a risk involved, of course, even the courts are not going to, and I'm certain that the courts are also not going to say that even if there's a risk to the life of the woman involved, then go ahead with the termination. Of course, the courts are going to be realistic about it. And if AIIMS or any recognized government body, the medical board gives an opinion that in such a case, even if it is beyond 24 weeks, and if it is a case of rape victim, then I think that the MTP law should be made more liberal.
Pertinent points. All pertinent points that you've raised over here, Advocate. And I think that's the tricky balancing act here. Where do you draw the line between judicial compassion and legal overreach? I'm going to circle back to you. Let me introduce the other guests as well. With us, Brinda Dige, social activist and Director, Global Concerns India, and Dr. Vageshwari Deshwal, Professor, Faculty of Law, University of Delhi, with us on the broadcast. Brinda ji, your views are always welcome here on News 9. What do you make of this? Should there be no time limit in such cases? How do we balance the rights of, let's say, the woman versus the fetus? And this is, a little bit of a balancing act that the court had to play out today.
See, the balancing act that we are talking about is a lot of understanding that is not being taken into consideration. Now, we are looking at a rape survivor, a minor.
Yeah.
And you and I know that when a baby is born, many changes happen to the woman's body, to the child's body in this particular case. And this child has to live with all of it for the rest of her life. So I welcome the judgment that it is the parents who have to decide. And the court is right in saying, change your law. I mean, she went to them when she was 24 weeks, and then the hospital did not do anything about it. But on what basis did the hospital or the law come out saying that after a certain amount of weeks, we will not allow you to have an abortion? So these are questions we must ask, because often the doctors are the ones whom we are asking, saying, give us your medical opinion. Now, medical opinion, they will all come and they will tell you that, the fetus has a life, it, nose and ears and legs and hands, everything have been formed, which is all right. We understand. But at the end of the day, it is the autonomy, the choice, the right of this woman who's carrying that baby.
Absolutely, absolutely. 100%. Dr. Vageshwari Deshwal, let me bring you in to this picture. Is the state right in raising the medical risk concerns? Let's talk about the medical practicality of all of this as well. Who should have the final say legally, the court, the doctor, or the parents? And the Supreme Court made it quite clear. The parents will decide, AIIMS will not decide.
See, this is a debate which is basically pro-choice versus pro-life. Even the state is not totally wrong, because there are concerns that at this stage, if the pregnancy should be continued with or not. And of course, the final call has to rest with the girl's parents, because they are the guardians. Either the girl herself has to take a call, but now in this case, since she's a minor, so it has to rest with the parents. But of course, you cannot saddle a girl or her parents with the responsibility of an unwanted child. In this case, it is the result of a rape. Now, what the state does in such cases, that even if we have to carry the baby to the full term, the baby is to be delivered, and thereafter the baby is to be kept in foster care and later on handed over for adoption. Now, herein what the doctors are saying is that at this stage, abortion would be very risky for the girl. And that is why they want to continue with the baby, because abortion would be risky. Carrying the child to full term would increase chances of the baby's survival also. Okay, so at least the child would be healthy when it is born, and the child, because if we are talking about that pro-life debate also, the child also has a right to a healthy life. See, beyond 24 weeks, it is the medical opinion that has to be taken. Of course, the final decision rests with the parents, but of course, this is something which needs to be deliberated upon. We cannot just say without knowing the exact condition of the child. There is a medical board which has been constituted by AIIMS, in which you have a radiologist, you have a pediatrician, a gynecologist, there's a psychologist. So there are multiple people who have to put their heads together and decide. So they have given their opinion. Finally, let's see what the court has to say.
Court has put out its own statement and verdict. But Advocate Agarwal, let me come back to you. Tell the viewers about Article 142, because it seems to be this overarching power that the Supreme Court had, at least in the hearing today. And can Article 142 going forward become a precedent for these future late-term abortions? Because we will talk about at 31 weeks how risky is termination medically. Is it even accurate to call this an abortion at this particular stage? This is deep into the third trimester that we're talking about. But Article 142, the tools that the Supreme Court actually used. What is Article 142, and can this become a precedent in the days to come?
Absolutely, and we have come of age now, and as they say, a lot of water has flown under the bridge all over the years, and the Constitution itself includes Article 142, which is the supreme power that only the Supreme Court can exercise, and that is the only power that no other court can exercise that power. In the interest of justice, the Supreme Court can overreach even the statutes which are there. For example, just to give another example to you, under the Hindu Marriage Act, a marriage cannot be broken, a divorce cannot be granted on the ground of irretrievable breakdown of marriage, because that ground is not available in the Hindu Marriage Act. So you have to go through the regular divorce cases, divorce laws. But Supreme Court, if it sees that yes, a lot of injustice is going to be caused to both the sides, if we stick to the technicalities, then divorce will not be granted. But to bring peace to both the families, then divorce can be granted by the Supreme Court by exercising. It's like a Brahmastra, as we say in Hindi.
Yeah.
So this is the supreme power that the court has, and which cannot be exercised either by the High Court or by the lower courts. This power is exclusively with the Supreme Court. Having said that, in this particular case also, in the interest of justice, in the interest of the concerned person, in the interest of society, because justice should not only be done, it should appear to be done. And as the maxim goes, justice delayed is justice denied. So if there is going to be delay in justice, which is granted to this rape, to this particular rape survivor or any other rape survivor, whether she's a minor or whether she's a major, then a lot of trauma is going to be caused to her, to the lady in question, because it is going to be the pregnancy is going to be against her wishes.
Yep.
There's going to be psychological trauma. She has to, how is she going to bring up the child? There's so many questions involved: her career, her body choices, the flouting of her fundamental rights, the body autonomy that she has. So, keeping all these things in mind, even if the statute, MTP Act, bars a person, from having a termination, a lady having a termination pregnancy after 24 weeks, this supreme power which the Supreme Court has can be exercised, keeping in mind the facts and circumstances. It cannot be a general law. The Supreme Court is not changing MTP Act itself until the MTP Act decides to be changed, changed by statute. However, keeping the facts and circumstances of a particular case in mind, the Supreme Court under 142 can grant justice to the person concerned.
All right. Many thanks for helping the lay people out there and, brushing up some of my own, legal terminologies over there as well, Advocate Agarwal. Brinda Rige, at 31 weeks, how risky is termination medically? We earlier heard Dr. Deshwal, she was saying that, the state is also not wrong in many of those aspects. Is it even accurate to call this an abortion at this stage? What are the risks to the minor's long-term health, even if the abortion, does take place? Is delivering and giving up the child for adoption safer in terms of medical standards? Can and should mental trauma, essentially, and why I'm asking you this is, can and should mental trauma outweigh the medical risk in this kind of a case?
So, like it was pointed out by both the panelists, the medical, physical trauma, danger, whatever it might be, that cannot outweigh. But what we are asking is, as I'm not a doctor, but the doctors have said that it might affect the mother-to-be. So the trauma that is going to be caused to her vis-a-vis the physical danger that she may be put in has to be weighed medically. But that said, we cannot be accepting that, okay, pro-life, life of that fetus is as important as the life of the mother, because we know that the mother does go through a lot of changes. Right now, you and I know that there's a lot of research that has been done, that already the mother's body has changed. Already the girl's body has changed. Their cells from the fetus have already entered her body, and that remains in the mother for the rest of her life. So we are looking at a lot of these things, but then we are coming to this whole thing of she has to deliver the baby.
Yeah.
And that is going to cause her physical trauma and all of that is yes, but mental trauma is a lot. You and I know that there is a lot of women who suffer postnatal trauma and postnatal depression. So we want to ask these questions. Should we put this child, she's a minor, through all of this? One side, she's going to go through all of this trauma where she's probably getting some counseling, the rape itself, and two, carrying this fetus in her. So I think it is right that the parents and the girl together, they decide. Uh, medical science has developed, improved a lot today. It is quite sophisticated. I'm sure they will be able to find ways and means to treat this girl physically. But the mental trauma sears through the soul. She has to live with it for the rest of her life. And I think those are things that we must consider when we are talking about bodily autonomy, when we are talking about a choice. It is this girl who's going to live another 70 years, 80 years. Lifespans have also increased. And should she live with this kind of a trauma? Just because my laws are not okay, because a doctor doesn't accept it, because a judge does not feel that is right, or a pro-life group that says, now this is what I want. At the end of the day, it is that child.
And there's a lot of stigma at play as well. There's a lot of stigma at play that delays reporting and then worsens these outcomes. You're absolutely right. And now that you've spoken about the advancements of, medical science, that's a great segue. Dr. Deshwal, you earlier pointed out that the medical board, was brought into, confidence. The entire board sits down. You've got a gynecologist. You've got, pretty much every department that's responsible for delivering a baby, a child, bringing, the offspring into the world. They are taken into confidence. But are doctors being put in a difficult ethical position here? There are ethics at play over here as well. Should medical boards have the final say? A lot of people questioning that as well.
See, India has always adopted a pro-choice stand. See, we got the Medical Termination Pregnancy Act way back in the year 1971. That was 2 years before America got its first decision in Roe versus Wade, wherein they allowed any right to abortion. That is another story altogether, that they've now gone back on that in Dobbs versus Jackson. So India has always maintained a pro-choice stand. We've had very progressive judgments earlier also, and especially after this 2021 amendment, courts have been very clear. That see, it is the woman's body. The child within the mother's body is also a part of the mother till the time the child is born alive. Moreover, there's always this debate whether life begins at conception or whether life begins after the child develops a heartbeat. So India has been very clear. We do not believe that life begins at conception. We are like that till the time the child doesn't develop a heartbeat, till 20 weeks. Only the advice of one doctor is required. From 20 to 24, 2 doctors, and that to mind it. When the doctor's advice is being sought, that is not about the condition of the child. There, the pressing concern is whether the mother is in good health, whether it is okay for her to miscarry or abort the child at that stage. So overall, we have always prioritized the mother's health. Herein again, I believe that the medical board is not only talking about the child, they are equally concerned about the mother's health also. So that is why they've been asked their opinion. That is what they've kept before the courts. Now finally it is for the courts to decide. And let me tell you, it's an ethical dilemma also. Nobody can have the heart to stop a beating heart, irrespective of whatever the reasons were behind this. So of course it puts us all in a dilemma. Judges, I believe they are wise enough and they'll take a very, very informed decision, and the medical board's decision will help them take the decision in this regard.
Well, you know what, Advocate Agarwal, we put out a poll earlier in the day, and some people on that, comment section also spoke about, can a minor in these kind of, horrible and heinous crime kind of situations ever truly choose, quote unquote, in such a, level of trauma? You earlier spoke about Article 142, but does this judgment, which people are saying it's a major watershed moment, it's a landmark judgment when it comes to reproduction, cases, does this judgment open the floodgates now?
I really wouldn't say floodgates, because as Dr. Vageshwari also said right now, it needs a heart to shut and open, a beating heart, and I do think that, it as it is, I think that as far as rape victims are concerned, one should really not expect them to carry on the pregnancy and give birth to the child, whether it is within 24 weeks or beyond 24 weeks. And as I said earlier, she has a right to have bodily autonomy, and she has free right to abort the child, even if it is beyond 24 years. But I would say over here that let us not look at this judgment today, as opening a floodgate, because I mean, to each his own, or to each her own. And I would really not encourage, medical termination of pregnancies in a thoughtless manner and in a very casual and careless manner, just because of this judgment. As I said earlier, that this judgment was in the particular facts of a case where the court said that under Article 42, we have to see let me quote unquote the word complete justice. So complete justice could be done in this particular case, because...
So then, advocate, what you're suggesting is that we then amend the limitations of the MTP Act in such a way. Be very careful and sensitive. But the Supreme Court said, how about you change the law? What's your perspective on that? Yeah.
Only for rape survivors, not in a general manner. Not every woman can come to the court after 24 weeks of a pregnancy and say, look, I want to terminate it for any reason whatsoever, because the rights of the child, the right of the fetus are also there. The right of the unborn child, they're also to be protected. The right of the father, who is going to be the father of the child, even he has got a right. The child doesn't belong to the mother alone. The child also belongs equally to the father. So all those things have to be weighed in the proper perspective, and only this judgment should be seen in the particular facts of the case and not as in a generalized manner.
Brinda Dige, let me circle back to the stigma. I think you're the right person to be talking about that. Stigma, delaying reporting, and then worsening of the outcomes. Maybe you can shed some light on that, and then we can circle back to what kind of amendments are we talking about here, the limitations of the MTP Act.
You're right, the stigma. So we are a country that does not like to talk about all these things. It's taboo. It doesn't matter what is our religion. It doesn't matter what is our socioeconomic status. The stigma that a rape happened, crime was committed, and now the victim is pregnant. Now we will not talk about it. We will not go to the hospital. We will not go and get this abortion done earlier. Now, all of this also means that my state, my government needs to start conducting a lot of education and awareness on one side. But on the other side, again, we come back to the trauma that this victim survivor will have to bear for the rest of her life. I'm not too sure whether it is our country or somewhere else, but there was this rape survivor minor who delivered a baby, and the rapist came back saying that baby belongs to him and he must adopt that child. Now you're looking at a lot of other ramifications. So when you look at ethics and ethical practices and what should be the ethical stance and decision, we want to now ask this question: when this child is given to so-and-so person because he thinks that he must be the one who should adopt this child, what are we telling this child? What are we going to tell for the rest of the child's life? How much are we going to hide? What trauma and what taboo will this child carry? So I think it is time for us to start talking about these issues, to give a lot of awareness and education, give a lot of awareness to our medical fraternity also. The nurses, the doctors, they are not very well versed in these things. They may know a lot of medicine, but they really do not know how to approach this area where a child, a girl, a minor comes and tells you. If you look at things abroad, when a minor comes, there is space for her, the minor also, to come and make a decision. And the decision does not say, bring your father or your mother and all of those. She is immediately sent to a counselor and said that you can take some more time. You have some more time. So there are rape victims and survivors who come immediately to the hospital and say, I think I'm pregnant and I don't want to have this baby, but I'm not too sure. Where are the counselors? The state has not got anything like this. They don't have any setup like this.
Yeah.
No, nothing of that kind. So I think we should not put the burden, like the lawyer pointed out. In this particular case, it is this minor and her parents. And the burden should not be placed. There is a beating heart. Would you have the heart now to medically terminate that heart? You're asking a minor to make such a profound decision. That's ethically wrong.
Yep. Absolutely. I think all of you ladies have put
the
best points possible. Yes, Advocate Agarwal, very quickly, then we'll go to Dr. Deshwal for a final comment.
If we're talking about rape, we must also have to keep in mind in the future that in India, we do not at the moment have the law protecting women from marital rape. So what happens to married women who are victims of what we call marital rape, and they do not want to carry forward the pregnancy? So is the MTP Act going to protect, if this law changes by this judgment today, are the victims of marital rape also going to be protected? That also has to be kept in.
Marital rape is not accepted, so they will not even accept it as
a profound question.
Yes.
Which is why I'm saying, it takes me back to my, first year college elective, talking about jurisprudence. At what point does law become cruelty? And is this really justice? Is this a moral gray zone? Maybe, Dr. Deshwal, you can come in on that. The MTP, its limitations, marital rape, all of this. And my apologies if I've overstepped in any way. I know I'll never know what this actually means for a woman to carry, a child, but that shouldn't essentially stop me from, at least beginning this discourse. I hope I've done, I've stepped the foot in the right direction. Dr. Deshwal, final comments, please.
Let me tell you, the law that we have, it's an excellent law that we have. See, while most of the world was not even talking about abortion, we were the country that actually allowed abortion. We had our Indian Penal Code, Section 302, Section 318. Abortion was a criminal act. 1971, we drafted a law. We also put the title in a way so that ethical and moral concerns can be addressed. So that we name the law Medical Termination of Pregnancy Act, so that we have some sort of a justification. This is a law which allows a woman autonomy. It gives her the discretion to choose how many babies she wants to have, what is the spacing she wants to have between her children, whether she wants to continue with the pregnancy or whether she wants to abort unwanted pregnancies. It gives her the total confidentiality also. I mean, she does not need anybody's permission. If she's an adult, she doesn't need even her husband's permission. She can just go to the doctor and get the child aborted till 20 weeks. Okay, so this is a very good law as it is, but definitely we are in a democracy wherein Constitution is our basic law. And the Constitution talks about right to life, which is the most vital provision which our Constitution also have. So right to life, if the mother has a right to life, she has a right to a dignified life, she has the right to a stigma-free life. So we have to find a midway wherein we are also talking about rights of unborn children. This is also a jurisprudence that has been developing. Of course, the mother's right, one who is already adult, alive, her rights have to be given precedence over the rights of a child. Yep. But then again, as the medical board, these are the reasons, because they decide a fact. I mean, they don't have a decisive power. They just give an opinion. Okay. So the medical board has to see what would be the status of the child if the child were to be born, whether the child would be able to survive. See, we would not want a child to be born in a manner that it leads a severely impaired or a handicapped life, which would happen if we were to deliver the baby at this point. Now, most probably, see, what the court is also going to say is whether there is a possibility of the child surviving. So we will have to see whether the bench says that terminate the child or whether the bench says that deliver the child.
So the rights of the woman, the rights of the fetus, the viability of the fetus, limitations of the MTP, getting to that middle ground. But needless to say, I think one thing that we can collectively, draw consensus on is the fact that this is a landmark moment for reproductive rights, what happened in the Supreme Court today. Many thanks, ladies. Advocate Agarwal, always a pleasure to have you with us. Brinda Digeji, many thanks for joining us. Dr. Deshwal, many thanks for your insights. This is not just a legal battle. This is about who owns a woman's body when the law, the medicine and human morality collide. But we're going to leave it there. Let's hope for good sense to prevail, and so that we have better middle ground and pathway when it comes to the Medical Termination of Pregnancy Act. We're going to slip into a quick commercial breather here, but on the other side, we're going to talk about the dangers of deepfake. No OTP, no warning, and a drained bank account. How did that happen? And Aadhaar was cloned. Don't go anywhere. That's coming right on the other side.
बेबो का एक ही रूल, रोज खाओ अंडे विदाउट भूल। 'Cause eggs are good.